Hi you guys, happy Sunday and welcome back to my channel. So the ad hoc committee on Friday decided to conclude the terms of reference that are going to assist them with the proceedings of how they're going to handle the investigations that they're going to undertake because of the allegations that were raised by General Mkhonazi. So they have in a way semi-adopted the terms of reference, but I don't think they're fully, because there's still some other parts that still have to be amended. So they took a resolution that they have to ensure that they deal with the administrative part of these proceedings before the end of August. So it seems like by September they would have started with the whole process of the inquiry or the investigation. In this video I wanted us to look at 5 parts that, or 10 parts that they've dealt with in that ad hoc committee that I think are very important for you guys to know and note as we're about to embark on this process of these inquiries. Number 1, guys, they spoke about the classification of information, that there's information that is classified that has to be declassified for purposes of this inquiry, and that they have to make an application to the Speaker of the National Assembly, which is Togotitiza, who has to make a determination of whether this information has to be revealed to them.
In the paragraph, if we agree that such information will be requested, let's just agree that within the legal framework that is in place in the country, the committee will make an application to have access. As to what the decision is, I mean, once we go to discuss whether it will be rejected or it will be granted, we are off the rail. Do you understand what I'm saying?
I do indeed. You see, for example, 2.12, it says there is a process for handling classified information. It's not all classified information. It's information that comes from Parliament that has been classified, not other classified information, which may relate to many of the issues that have already been investigated by the JSCI. So that classified can't stand as is. It should be classified parliamentary information. I think may make more sense there.
Yeah. But here the guidance from me. I want us to, when we leave this paragraph,
yes,
let's leave it with a common understanding that says there is a law which is called the Minimum Information Security Standards, which is applicable in the Republic and is an overarching piece of legislation regulating access to classified information. And
I read the protocol, yes.
Where we work in Parliament, there is a protocol on access to classified information. And that protocol is subject to the MIS law. And so honorable members here are saying, Honorable Barnard, where we may need access to information that is classified, what then becomes the procedure? And that's why I say, if your suggestion is that through the office of the Speaker or whatever authority is allowed by law, the committee will make an application to have access to that information.
So to me that is fine, but it has its good and bad. The bad is that Togotitiza might not want to approve of this application because of the fact that it's classified information, and they will say that it's sensitive information that no one is supposed to know of, even though the EFF did raise an argument that this information is supposed to be accessible to the members of Parliament, especially if it contains the criminal natures.
Point 15. The committee further acknowledges that only full, not alternate or co-opted members of the committee may access such documents. Now, as Action SA, we reject this and request for the removal of this section. The Speaker cannot unilaterally make such determinations without even consulting the committee, particularly as the implications were never discussed. Furthermore, the protocol developed contains no legislative provision that necessitates the inclusion of this clause, Chairperson.
Chair, I'm in agreement with Action SA. When you read through the protocol, it says that any members of Parliament have access, provided it's related to, I actually read it this morning because I also missed it. It's 2.15 and I'm seeing it here on my notes. Where is it? It doesn't exclude anybody. It says any members have access to it. It doesn't, I didn't see. So maybe you can refer it to me in that protocol.
So yeah, this has happened before. This argument of the speakers normally gatekeeping this classified information. For example, in Amstel, if you guys remember the Seriti Commission, as well as the Zondo Commission, as well as the Pala Pala, of which the MKP did raise the issue of the Pala Pala, even though they were quickly stopped. Let me guys play you that clip.
Before you pass, because I heard as well my colleagues. But why when I raised this thing last week, I said it very clearly, Chair, that I understand the word classified declassification of matters in this country. Hence I said this Dutch Roman law is giving us trouble. But be that as it may, we can't be told by an executive, a minister, saying that he classified the matter like Pala Pala. That's what I said. And I guess we have to be very, very clear, like the Honorable Matthias said, we cannot hide anything here under the word classified. Some matters have to be, the public wants to know exactly what happened in these matters.
Yeah, but
and I hope
Honorable Skosana, what you are doing now, you are no longer debating the terms of reference. You are no longer debating the terms of reference.
I'm making an example, Chair. And we are right to make an example, Chair. Am I right?
No, listen, you have made this example not once in this meeting.
Chair. Thank you, Chair.
And the example of Pala Pala that you have made, we have had it, and you have emphasized it. And I don't think that there is any one of us who will forget that you have made that example. The overriding principle that we leave this paragraph on is that all of us agree that within the framework of the law that is there, if the committee wants to have access or to view certain information, a facilitation will be made, or an application or a request will be made.
So this ad hoc committee, it is true that it was created from Konazi, but it seems like the MKP just can't forget the issue of Pala Pala. But I think that they could have used that as an example, even though they've done that. But I think that the purpose was to not focus on Pala Pala. But I'm going to use those cases as an example to show that classified information was refused to be declassified by the national speaker. By the Speaker of the National Assembly. So I think that it's a matter of protection, accountability. The Speaker wants to protect, people want accountability. But in the nature of these proceedings, high chances they might want to show the information, they might want to declassify the information, because classifying it will raise a lot of eyebrows, especially the fact that everybody's looking into this situation. So I think it will work well with Mkwanas, because it will show his proof. He will be able to prove his claim beyond reasonable doubt. So with the Zuma case as well, the speaker refused to declassify information until the matter even went to the Constitutional Court. The Constitutional Court overturned that decision to say that the information should be allowed to be accessible. And also, guys, it's important to note that Didiza is of the ANC. She's the speaker of the ANC. She will by any means and in every effort ensure that she protects the people of the ANC. But since we see the decline, even this article shows that the numbers of the ANC are declining. I think they should just save the small dignity that is left of the ANC. But still, I wouldn't be shocked if they just finish it off through this ad hoc committee by lying even more, or making the work of the committees hard, or the work of the commission even harder by concealing certain information. They'll say that they're blocking sensitive information. So the Constitutional Court already has decided on something like that the speaker should not hold on to information and unilaterally decide on what should come out and what should not. So hopefully the speaker, Didiza Togo, will not find herself or put herself in a situation whereby now people have to even go to court to declassify the information. Hopefully she won't be a hard one when it comes to that. The second one that they discussed was the issue of the oversight, that after they've decided as the committee, they've made recommendation, other committees that are relevant should ensure that they implement those recommendations. Even in the Commission, you guys, you know that they made a lot of recommendations, but not all of them have been implemented. Even in Marikana, not all of them have been implemented. So now they want to push that thing of oversight, that relevant committees should ensure that they implement whatever recommendations that have been made.
That play oversight on the respective institutions.
Yeah.
Is that the part that you want to have included?
Yes, and those committees must do oversight. So it must be captured. So it doesn't just end that we've referred matters and there's no follow-up because we're wasting our time.
That also definitely is to prevent these findings from collecting dust, and is to ensure that there's no political influence, because lack of implementation is because of political influence. So hopefully we will see a situation whereby people in these committees, they're going to be able to implement whatever recommendations that are going to come out from the ad hoc committee. Another thing that was discussed was the issue of the witnesses, that witnesses need to get a maximum of 30 minutes in order for them to say whatever that they have to say to the committee.
Given strict time frames to do an inquiry. So with what that chair, our understanding was that we agreed on 20 minutes, but also with a disclaimer provision that allows the chair to allocate more time for members that still want to continue where the chairperson deems it necessary. I think, Chair, we think, Chair, that was our understanding. I also,
in situations like this, we deal with maximum, which can be exercised with flexibility. So I need clarity on that. A minimum of 30 minutes. That's something very odd.
Let's put the maximum, but also with the rider that where necessary, a member may have his or her time extended.
20 minutes is fine as okay. Let's deal with the maximum only, because we can't impose a minimum. A person can have one question, which can be 1 minute. So let's not impose a minimum. Let's impose a maximum rather of 30 minutes, Chair. That is my view, not 20 minutes.
And then if we go for 30 minutes, do you still allow the chair to exercise a discretion whether the time can be increased or
Chairperson.
Even above 30 minutes?
That will be on the discretion of the chair, and we will believe in the wisdom of the chair that he won't be doing it because it's in the rules, but he will be doing it because it's relevant.
As you guys have heard, the discretion still lies with the chair, that the chair has to decide whether they should extend the time. I definitely think that Mkonazi's testimony will definitely not be for 30 minutes. It will be more than that. And I think that will help with the situations of people like Senzo Mchunu, Cele, and every other party from coming to the ad hoc committee prepared, because people will want to go prepare themselves, have speeches that they're going to say, then they'll say endless speeches for 5 days. So I'm happy that they're trying to minimize the time so that people can get to it, instead of telling us stories that are not even related to why the committee was even created or what General Tlatlam Mkonazi said. So I think that it will definitely help with controlling the narrative. But I think that, like, realistically, 30 minutes is too small for such allegations that contain so much criminality. I definitely think that there's certain other people that are going to be there for more than 3 days, that are going to be giving testimonies for more than 3 days, depending on whether people are lazy or not. Also, they spoke about the institutions that are accredited to assist people with sworn statements, legal practitioners, legal aid, and they solidified that point that people need to use those services that are available to them.
Chair, I think the assistance that you are trying to provide here is assisting, because, Chair, if you are to read 4.7, 572, 573, they give a detail of what would be a responsibility of the legal advisors or legal practitioners in committee meetings. So in that context, you don't need the wording that they've started with that says legal representation will not be allowed. And I agree with you, Chair, that it causes some confusion, ambiguity, and it's unnecessary. So my view, Chair, is that that sentence must start where it says the witnesses. They say, however. No, on the first paragraph, if you can go up. My view, Chair, is that it must start with saying the witnesses will be allowed to have their own legal assistance at their own cost and continue. Because in the below sentences, it gives a clarification of what will be a role of legal advisors or legal practitioners during our committee meetings. So that one, Chair, I'm in agreement with you. It causes confusions and it is ambiguous.
And I think that's a good thing, especially for people that don't even understand anything about the law, don't even know what to say and not to say, and whether that will be them implicating themselves or cremating themselves in whatever. So I think that it's very good to have legal practitioners around that will assist with sworn statements and what people have to be careful of before they can even go before the committee and even end up putting themselves in those situations and ditch up on themselves and end up making this whole situation even harder, that they end up even facing criminal charges and stuff like that. So I'm very happy that they've considered legal aid, they've considered other institutions that administer sworn statements. And they also spoke about broadcasting of fish. I think broadcasting, we all know that these commissions are always broadcasted, and I think it's a good idea to broadcast everything.
I don't think it's necessary for us. I mean, it goes without saying that if it's not possible, it's not broadcast. But I think when we put it in there, we open up to there being okay for it not to be a broadcast, but it should be prioritized that it is.
Honorable, Andy, do you understand the context within which Honorable Matthys is raising the matter? Where it's for the protection of witnesses, we all agree. But the manner in which it is written, the manner in which it's written is implicit, and it has to be corrected.
So I think broadcasting is definitely a good one, especially for Mkwanas, because we don't want anyone's words being twisted. And if things are broadcasted, people will get to hear it from the horse's mouth instead of the media that will have to tell and end up twisting word and end up paraphrasing things, and it ends up losing the meaning or losing the gist, and it seems like someone is lying or something like that. So I'm happy that they're going to broadcast it all right through. And they also spoke about the meetings, that meetings are supposed to be held physically, and that people that want to come and appear virtually, they need to make an application to the chair of the committee, and then the committee has to decide. And I think that is very important, because in the first part where they spoke about the discretion of the chair, I'm very worried about giving so much power to the chair, especially since the chair is an ANC chair. There's certain things that the chair might not want for someone to say, because they see, oh, this person is cremating themselves, or this person is getting in more trouble, they're putting themselves in more trouble, and they want to cut that person very quickly, because the discretion is with them whether they want to extend the time or not. And I don't think it's good to give so much power to the chair. And I'm happy with now with people that want to appear virtually, they want to give back the power to the committee, because someone might feel like they're in danger, but the ANC wants to expose that person and they want everybody to see. They will end up agreeing, we understand, especially the chair. So I'm happy that they're giving back the power to the committee, and the number of people are going to decide on it. In as much as, yes, the GNU and the ANC are still in the majority, but we still have parties like the EFF, the IFP, or we still have parties like the EFF, the MKP, Action SA, that are going to, try to fight for whatever that will seem as if it's unfair. So I'm happy that Julius Malema did fix that the committee still has to have the final say, not the chair. And I'm worried about the one of 30 minutes. The chair can easily see that, okay, Senzo Mchunu is saying too much, so we won't give you more time. Rather go home and protect yourself. I think that one is very dangerous to give a chair. But I guess it is what it is. They've agreed on this one.
Chair, I think it must say that hearings will be held in public, and there will not be any virtual hearings. That should be the statement. And then upon application to the chairperson, that for whatever reason, the committee will then consider if indeed this matter cannot be heard in public. in physical sitting. Yeah. Because we must encourage the physical sitting. So it must not come across as if it gives an easy way out of not appearing physical. It must be the emphasis, whatever you write, the emphasis should be the hearings are going to be held in public and witnesses are going to be expected to appear in public, physical. Unless a special application is made to the chairperson for the consideration of the committee, then the committee will determine if that application is correct or not.
The last point that I want to talk about, number 9, is the issue of external legal counsel and the expertise that are external. And they want senior counsel, senior advocates to be the ones that are going to assist them in this process. One of the biggest problems I have about this is that it will be too much legalized. There'll be too much legality and overuse of the law in this whole proceedings, of which it is the law. We need the law, but it should not be overexcitement of the law.
I don't know if you don't agree, I have no problem, but I think we ought to be very specific that the legal expert must be a senior counsel. Yes, that we're not involved in procurement and all of that, but as a principle, to accommodate what Honorable Matei says, because the next thing we just say legal expert, and then they were exposed to some problems that we did not deal with from the beginning. We say the senior counsel will be appointed, blah, 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 but there must be something that says senior counsel that deals with this aspect. Thanks.
And whoever he chooses to assist him is not really it's neither here nor there, but the person responsible for giving us the support is the one
senior counsel.
Is the senior counsel. So if we're now going to add words to specify that the juniors will also be there, it's just overcomplicating. I think the initial one was just fine. It was direct, concise, and simple.
Secondly, advocates are very expensive, and I think that it is something that we have to note that advocates are very expensive, and also advocates can be really robust. For example, if you guys remember Marikana Commission, Dalimpof was on the side of the widows and questioned the state witnesses very hard. It was very hard on them. But some of the attorneys that were appointed, they were very, not cross-examining the state attorneys very well. It signaled as if, they have political affiliations with these people. They're not doing their job effectively. They were very, calm about situations instead of really questioning people just to find out what the truth is. But we have Ishmael Seminyas. We have Advocate Vincent Malekase. Those are some of the advocates that were really criticized on the way they were questioning the witnesses, especially state witnesses in the Marikana Commission. So in this instance, we have a situation of political association versus, being a counsel, being the servant of the law. We have that situation, and I'm just interested to see how that plays out. I'm very skeptical about the fairness of the process, especially considering that the truth of the fact of the matter is that everybody is associated with some political party. Whether you want to agree or not, you have certain preferences. There's certain things you don't like. There's definitely people that don't like Umkwanas, to a point that the fact that he said what he said about trade unions and them being the way they are brutal, they couldn't wait to swallow him alive. They couldn't wait to eat him alive. So that should give you a clear picture that there is people who are advocates, and anywhere there's people that don't like Mkhwanazi and don't want to give him those hard questions, bring too much of the law so that they can discredit him, to say that why did you do this? Why did he stem in terms of the law? So I think that use of senior counsels, advocates, it has its good and it has its bad. And then lastly, they spoke about who to appear. So they agreed that they're going to appear the National Police Commissioner Fanny Masemola, the Deputy Shatarak Sibia, the Minister who's Senzo Mchunu, the former Minister who's Peggy Cele, as well as Lieutenant General Dadlamkwana. Those are some of the people that are going to appear. There's two problems that I have about this. Number one is that whatever Mkhwanazi will say, they want to respond to it. They won't tell us their side. They want to respond to what Mkhwanazi said. And I think that is going to be a problem. And
so the draft program essentially takes an institutional approach, which will then mean that the first institution that will appear before the committee will be the SAPS. And the first person in the SAPS will be General Mkhwanasi. And then there are other four, which is General Masemola, who is the accounting head, the minister who was there, Minister Mtunu, and the deputy commissioner, who was there, Commissioner Sibia. And then the current minister and his deputies. And thereafter, the proposal is that the committee will then order the list of witnesses in line with the terms of reference, the way we have agreed that the committee will order the list of witnesses whose names would have emanated from the presentation that General Mkhwanasi would have made before the committee. And then once we are done with the SAPS and all other witnesses related thereto, we will then move to the next institution. We will take those institutions and witnesses one by one until we are finished. So what the technical team is proposing before this committee is for the committee to note this draft program. We may not exhaustively finalize it now, but allow the technical team to initiate contact with the witnesses.
The input as Mr. Cele definitely needs to be on there. Thank you.
Okay, Andile, you hear that the name of the former minister Cele has been added to the list. He's no longer in office. Of course, the committee is putting the name there. We will come, and once we have listened to those that are there, order the manner in which Cele and other witnesses will be appearing before the committee.
But I still think that it's a problem in the context of people preparing, people rehearsing their responses, people responding to Mkhwanasi more than telling their side of the story. The side of the story might be to respond to Mkhwanasi, but we want to know, why did they disband the task team and all of that. Someone will base their answer based on what Mkhwanasi said. You get, guys, what I mean? And yeah, it's a good thing. Even in Zondo Commission, Abo Gordon, as well as the police generals in Marikana, were some of the first people to appear in the commission. But my fear is that people will want to defend themselves by any means possible. But at the same time, what can be done? What is it that can be done? If they don't call these people, they call them at the end. Who is going to set up the stage? Who's going to set up everything on what to use to question people and judge people? So yeah, it's quite tricky. This ad hoc committee works with regards to these entire proceedings. Also, this is clashing so much with the Commission of Inquiry, so because it's starting also on the 1st of February, the Judicial Commission of Inquiry. So I don't know how they're going to juggle around who to call when. Assume that when these ones call this one is going to be available on the side, because they want to start with Mkhwanasi. I don't know if the Judicial Commission of Inquiry also wants to start with Mkhwanasi, and how many days will they need Mkhwanasi for? Do they have all of that set out? But it seems like there might be those problems where people are going to run and say, no, I have to go to the commission first before I can come to the committee. I foresee some of those situations, because it seems like these processes are going to be happening simultaneously at the same time.
Must have been concluded within these remaining days of August.
Including contacts with the witnesses and request for documents.
Yes, Chair, that's correct.
And confirmation of dates of appearance.
Yes, Chair.
Thank you so much.
Still a whole full week, Chair, working days.
So I just hope that they'll be able to control the situation so that no one has an excuse of not appearing in the committee or appearing in the Commission of Inquiry because of, I'm appearing here, because we know that people always dodge. So I'm hoping that no one will be dodging anybody that is needed anyway. They'll be available for that. Also, they spoke about Mondays, that Mondays are constituency days and that they won't be able to meet up on Mondays. So we know that on Mondays there won't be the committee meetings, the ad hoc committee meetings. So
I was saying, please, in the consideration of the program, we must try by all means to avoid Mondays, because Mondays, as you know, they are constituency days, and it is going to complicate our life. Thanks.
That is a valid point, Honorable Member. Chief Whip.
So Mondays are out. And also, guys, shockingly enough, Masemola has not yet been summoned by the Commission of Inquiry, the Judicial Commission of Inquiry. And that has made me to be worried, because I thought by now they would have summoned everybody, unless there was someone him at a later stage. But he definitely has to be summoned, because one of the things that I know these commissions and some of the court cases they like to do is to exclude people that are very important, that are a very important puzzle to everything. They like excluding those type of people. So I'm hoping that they will get to a point whereby there's someone, Masemola. Now I'm talking about the Judicial Commission of Inquiry. Hopefully they will summon him to appear. But so far, what has been reported is that he's not been summoned. Really worrying, especially for a commission that is starting very soon. They should have summoned him by now. I don't know. Hopefully they will summon him at a later stage, because other things they get to do them as the proceedings goes by. So probably for now he's not of importance than Sibiya as well as Senzo Mtsun. But I'm hopeful that they will end up calling him. It doesn't seem like he doesn't want to attend. He's very much willing, but the fact that they've not summoned him. So in simplest terms, they have small touch-ups that they have to go and fix, but it seems like they've adopted the terms of reference. And I don't know what you guys think about all these things that they've adopted so far. Do you think that there's anything that will backfire at some point? Let me hear your thoughts. Tell me what you think. Otherwise, you guys, I'll see you in my next upload. Bye.